Hello, this is Matt on the Moon Lambeau channel, and I'm coming at you with another legal update because, holy hell, there's like 11 billion legal updates per day. That's a factual number right there. I think I've done an okay job keeping up with this stuff. It's actually a lot to track, though. There's so many things developing, and as things progress, it kind of like, at least for me, maybe because I'm just not a lawyer, but it just like it blurs together like some of the parts of the stories that I've covered. I retain a fair bit, certainly, but then I go back and like, wait, that this story was relating to something else from, was that the one from 3 days ago or the one from 2 weeks ago? And then I have to go look up all sorts of court documents just to get my facts straight on this stuff here. It's not a complaint. It's just acknowledging that there's a lot going on here. And so here's the headline from Crypto Newsflash. Ripple vs. SEC. Briefing schedule for motions to dismiss by Garlinghouse Larson are set. And I'll tell you what, I would love to see the case against Garlinghouse and Larson. I'd love to see them dismissed. I don't know if that's going to happen, but part of the reason I'd really love it, I mean, yeah, look, you could say it would like set a tone for things to come, perhaps. I don't think it would actually have any sort of legal implication of what's going to happen with Ripple, the company. The charges against Ripple, the company, having sold XRP as an unregistered security. But I would certainly love it at a minimum because it would set the tone, a new tone in the world of crypto. And it would make people wonder, like, wait a minute, they just, so Brad Garlinghouse and Chris Larson, they didn't do anything wrong? And it's so clear that they didn't even have to go to court? I would love for a Bitcoin maxi troll to suck on that one. That would be absolutely, truly desirable. But I don't know if it's going to happen. I haven't really seen a bunch of lawyers share their opinions on if they think that's particularly likely or not. They've been covering just the legal facts of it, but I haven't gotten a lot of opinion on, specifically for Brad and Chris, what are the odds of them actually just completely getting off the hook without going to trial. So we'll just have to sit back and see. But I do have opinions from a number of lawyers in this particular video. I think, at least 3 lawyers. To be clear, I don't have a legal background of any kind, not offering legal advice. I don't have a financial background of any kind, not offering financial advice, and you should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who likes to talk about Ripple and XRP and crypto-related stories, and I make YouTube videos as a very fun hobby, and that's all that it is. The legal battle between the U.S. Securities and Exchange Commission and Ripple continues to pick up steam. No less than 4 documents were published yesterday via Court Listener. You see what I'm talking about? 4 freaking documents in a day. It is a lot to track. Anyway, one of them revolves around the schedule for the briefing of the motions to dismiss filed by Chris Larson and Bradley Garlinghouse. As CNF reported, both Ripple CEOs have each filed a letter stating their intention to file a motion to dismiss the SEC's amended complaint against them. And that's a weird way to word it, both Ripple CEOs, because technically, so Brad Garlinghouse, he is the CEO. Chris Larson used to be the CEO, but he is no longer. So I don't know if that's just an error or if they're trying to say, like, they both have the title because one of them used to have the title. That's weird to me, but whatever. It's like he's the president, It's customary for you to be called, like, Mr. President once you leave the office here in the United States, but what it is, like Mr. CEO. I don't know about that. Anyway, just 3 days ago, the SEC denied those motions to dismiss based on scienter liability. According to the SEC, the 2 Ripple executives had avoided knowing that XRP could be found to be a security in order to profit financially. And so that's scienter, that's a legal term, and it's indicating that in order for Brad Garlinghouse and Chris Larson to be found guilty on the charges against them, it can't just be proven that what they did actually happened in terms of the sales. It has to be proven that they knew that it knew or should have known, something to that effect, that it was a no-no. So I think that the evidence is on their side, though. So even if this goes to trial, if it goes that far, it's pretty damn clear that all the evidence available to Brad Garlinghouse and Chris Larson was indicating that XRP was not a security. But anyway, the SEC told Judge Torres in the latest letter that they and the individual defendants have agreed on a proposed schedule for briefing the individual defendants' motions to dismiss. And here's a quote. The parties respectfully propose that the individual defendants' opening briefs be due April 12th, 2021. The SEC's briefs in opposition be due May 14th, 2021. And the individual defendants' reply briefs be due June 4th, 2021. So we're talking about, that's a 3-month time span, almost from now. But it's gonna fly by. It's just like we, just snap of the finger, and we're out of a bear market, the multi-year bear market. And here we are having good times. Anyway, excuse me. I have this little subheading: Ripple and SEC reached an impasse. Further, the Garlinghouse and Larson legal team has filed a motion to file a combined brief of 10 pages or less. Specifically, they seek to address several discovery issues on which we have currently reached an impasse with the plaintiff. The SEC has agreed on the condition that they also be entitled to a reply brief with the same page limit. In addition, the two parties were informed by Judge Torres that Joy Guo, whose name I'm sure I'm butchering it, G-U-O, I don't know, is it Guo? Joy Guo? I don't know. It's something like that. So anyway, Joy Guo, counsel for Ripple, was one of my law clerks during the September 2016, September 2017 term more than 3 years ago. The court does not believe this relationship creates a conflict, but will entertain any request to reassign the case. And so this is where we get to an opinion from attorney James K. Filan. I'm sorry, I don't know how to say your name, good sir, but I appreciate what you're putting out into the world of crypto here. Somebody tell me how to say his name. I don't know what I'm doing. I'm just a simple moon lambo. But here's what he wrote here as a short thread. So here you go. An order was placed on the docket granting the defendants, Ripple et al., the opportunity to file a combined letter motion of 10 pages or fewer. Along with that order, the court also notified the parties as follows. And it was that little snippet about the law clerk and that there was a relationship with the judge, just to make sure that there's full transparency. So that's that snippet I read you. And then James jumped in with his opinion here. And he wrote, everyone needs to understand clearly that this is not at all unusual in federal court for an attorney to appear before a judge for whom she or he clerked for a year. It happened with me and happens all the time. The court is merely alerting the parties of the previous position that attorney held or her staff. I'm confident that all counsel already knew this. Nobody is going to question or should question Magistrate Judge Netburn's impartiality. She is simply making a record, which is what all good judges do. So do not read anything into this at all, and please don't think it's a big deal. It is a non-issue and will not impact the case. Thank you. Which he means emphatically, and you can tell because he wrote that part in all capital letters. And so I'm glad that he said that too, though, because it's just like nipping in the bud before stuff happens. Because sometimes, you get fringe members of the XRP community coming up with some interesting ideas, let's say, surrounding certain things, going down a particular tinfoil hat route. There's stuff like that. Anyway, then attorney Jeremy Hogan jumped in on that thread and wrote, yes, not a big deal and happens all the time, especially when big law firms get involved. And then here's attorney Jesse Hines chimed in with his opinion on this topic as well and wrote, agree with Jim's analysis here. Let's not make this into a riddle. Exactly. Don't like the riddle stuff. We don't need that nonsense. There's enough awesome stuff happening with Ripple and XRP in terms of real world adoption that we don't need the silly, the little cartoon bear and 589, all that crap. Oh my God, that stuff really burns my biscuits, guys. It really burns my biscuits. Ain't nobody got time for that. Was there something else I wanted to cover too? Oh yeah, here we go. Check this out. Somebody asked James though, James Fulan. Thanks, James. How often does this lead to a case being reassigned then? I assume not frequently, ? And James responded with, I don't think I've ever seen it happen. And then attorney Jesse Hines jumped in and wrote, yeah, first someone has to ask for reassignment, which no one wants to do because it feels like you're accusing a judge, right? So I can totally understand why they wouldn't. And it also doesn't seem like in any sort of way it actually would have some sort of material impact on the case. It just, I see no indication that it matters, and all these attorneys are telling me that, so I'm going to yield to their sage wisdom on this particular one. But I'll wrap up there. That is it for this latest Moon Lambo Hot Jam. I am not a financial advisor. Do not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Lambo.